Joe, could you?
Now put.
I'll hear the Honourable Rick Barker.
Chair, I've got two questions I'd like to put to the Minister. The first is, if the Minister's finished his texting, the first is a very serious question. There was a case that went to the Supreme Court where the presumption in the law as it stands was that if a person had a certain amount of cannabis or a certain amount of any particular drug, they were deemed to be dealing, not just a suber. They were deemed to be dealing. And the Supreme Court looked at this and in the end chose not to strike down the legislation but gave very careful consideration to it, and their fault with the legislation was that there was a presumption in it of guilt of a charge, that there was not the presumption of innocence. Now, this is, I think, a very serious issue, and as I understand the legislation putting forward here, that if people have a certain amount of material that's presumed to be that's for personal supply, but if it's over a certain amount, then there's a presumption of dealing, and that's the charge that people get. Now, I just want to know, has the Minister and the people who are drafting this legislation taken into account that Supreme Court decision? It was a split decision, and have they fixed what the Supreme Court saw as the deficiencies in the legislation passed by this Parliament? And I'd like the Minister to give me an explanation to that. The second is a question. I've just gone and picked up the supplementary order paper here, and I see that in 4D, subsection 4 and others, that the definition is possession of a person of 56 grams or more in total of any product, including the cigarettes, in drug forms, including flakes, tablets and capsules. Now, I thought by being so specific, the general rule of legal interpretation is if there is a number of items specified, then the list is deemed by the law to be complete. Now, that's what has been interpreted. I see one of your officials shaking their head. But I would say to you, Minister, is it possible that if someone had a powder or a liquid form, that they would be able to say that they are exempted from the scope of this legislation, because by any definition a powder is different from a flake. A liquid is different from a solid form. And the Minister may not know it, but a number of drugs can be called, we've got methamphetamines and pseudoamphetamines, usually in a crystal form, but the drug can be used, can be transported in a liquid form. So I'm just concerned that the legislation we've got here is very narrow in its definition of flakes, tablets and capsules, and does not cover powder and liquids. And I would like to be assured that those matters that have been raised have been considered by officials, and the Minister to advise me that the issues contained in them have been dealt with. So if a person is caught in possession of a liquid, this will not in effect defeat the purposes of this legislation, because the Minister has not specified a liquid. And I would also think that a powder is different from a flake. A flake is a chip or a chunk. A powder is quite differently defined in the dictionary. I've had it taken time to check. And I'd like the Minister to respond to that and say that yes or no, they haven't taken into account the recent Supreme Court decision, and yes or no, they haven't taken into account whether the drug comes in the form of a liquid or in the form of a powder.
Members, we move to Ian Galloway.
Mr. Chair, I did wonder if the Minister was going to